Welcome to Judicial Review Part 2. So in Part 1 we looked at what was judicial review, which we said was judge review or judge or High Court supervision of the decisions of public bodies that affected people's legal rights. And we got an overview of the circumstances in which the courts will review the procedure followed in making the decision, and the very rare circumstances in which they will review the substance of the decision itself, so that idea of administrative unreasonableness. In this topic we're going to look at the principles of natural and constitutional justice that underpin judicial review. So as we said, when the courts review a decision made by a planning authority, they do so based on the procedural rules that apply under the relevant statutes, so the Planning Acts in the case of a planning decision, and they also compare the decision to a set of principles that are really at their very heart principles of fair play and common sense. So did the decision maker follow fair procedures in making the decision? Do they make a common sense decision? And these are expressed in legal terms as the principles of natural and constitutional justice. So we saw in the last lecture some examples of these. So audi alteram partem, or the obligation on the decision maker to hear both sides equally. So not to give one side a better opportunity to put their case forward than the other side, or not to disadvantage one side in the running of their case. Nemo iudex in causa sua, so no man shall be a judge in his own cause. In other words, the decision maker should have no connection to either of the parties or the subject matter of the decision. He should be totally impartial, or she should be totally impartial. Constitutional justice, which we're going to look at in detail, it's a set of procedural rights that arise out of Article 38 of the Constitution, which is the right to a fair trial. Ultra vires, which is the idea of outside the powers, so public bodies have only very limited powers to act in accordance with the legislation that sets them up. If they move even an inch outside of the powers given to them by the legislation that establishes them, they are outside of their powers, and anything they do outside their powers is invalid. It's almost like if you think about the lines on a pitch, and once the ball goes outside the lines on a pitch, you are outside of your valid football action, if you like, and it causes a penalty. So legitimate expectation, the idea of holding a public authority to a promise made. So a public authority makes you a promise, you act in reliance on that promise in some substantial way, then they must uphold that promise. And then the duty to consider only relevant matters, not to take into account irrelevant matters, and to avoid improper purpose. So to make the decision for the right reasons. Not because of some bias you have towards the person, not because of some information given to you in the course of the decision-making process that's not really relevant. So I gave the example in the previous lecture of if the objector to the planning permission put forward information that the landowner had previous criminal convictions for theft, that's not relevant to proper planning in the local area, which is the only consideration that the County Council should be looking at. And they cannot refuse the planning application based on a theft or a road traffic conviction. They could refuse based on a Planning Act conviction because that is a relevant matter, and it's actually provided for in the legislation that your previous planning history is relevant, but not your previous history in other areas of your life. So like scurrilous accusations that you cheat at cards or such things, they're not going to be relevant to the proper planning in the local area, so they're not relevant matters and they can't be taken into account. So they're the principles. We're going to look at them in a little bit more detail. So audi alteram partem, aude means to hear, alteram means both, and partem sides. So the requirement is to hear both sides equally. So this means that both parties must be given notice when the hearing will take place. If you're not given notice of the hearing, how are you supposed to attend and participate? You must be given adequate notice. That means in sufficient time to prepare your case. You must be given notice as to what will be the subject matter of the hearing. So what will be the challenges or the accusations levied against you at the hearing. And you must be given your right to have your say at the hearing. So it's kind of full range of participatory rights are captured by this idea of hearing both sides. And it also captures the idea of how the decision maker behaves when they're running the case as well. Do they let both sides make their points equally, or do they cut one party off and refuse to let them speak, which sometimes happens. So in Gleeson and the Minister for Defence, there's an example of that. So this guy was dismissed from the Defence Forces. He wasn't told why. He wasn't allowed to attend the hearing. He wasn't allowed to make any representations to the deciding body. So none of the principles of audi alteram partem were followed there. And when he appealed to the High Court, so decisions of dismissal from the Defence Forces are overseen by the High Court like other public bodies, the High Court quashed the decision. Nemo iudex in causa sua, no man shall be a judge in his own cause. This is the requirement of impartiality on the part of the decision maker. So in O'Donoghue, they said the test to be applied in determining whether a tribunal is impartial is that a member is not impartial if his own interest might be affected by the verdict, or he is so connected with the complaint that a reasonable man would think that he had come to the case with prior knowledge of the facts, that he might not be impartial. So if the judge knows one of the parties to the case already through their social circle, they shouldn't sit and hear the case. And similarly, county council planning officers shouldn't make decisions about cases where they know one of the parties are related to them or something of that nature. Constitutional justice then is this overarching idea that captures a lot in it, and it's grounded in the Constitution. It's grounded in Article 38 of the Constitution, which sets out the right to a fair trial. And the Constitution guarantees the right to fair procedures in trials, and that idea of a trial, we think of as a criminal trial before the courts, but any determination of your legal rights is captured by the word trial. So constitutional justice applies in any scenario where someone makes a decision that affects your legal rights, whether that be your employer deciding to dismiss you, the planning authority deciding to refuse you planning permission, or the grants authority deciding to refuse a farmer a grant. And the rights that are encompassed by constitutional justice include the right to know the case you will have to meet and the evidence grounding it, the right to adequate notification of the hearing, the right to be represented by a lawyer or a person of your choosing. Now in court you can only be represented by a lawyer, you can't be represented by anybody else, so you either have to represent yourself or hire representation that are recognised by the court. But in planning tribunals and county council planning processes you can hire any kind of representation you like. So you get planning consultants, participating in those processes. The right to cross-examine. So you can ask questions of the person from the other side who's making accusations against you. The right not to incriminate oneself. The right to have both sides heard. The right to be given a reason for a decision, and the right to review or appeal of a decision. And when you're looking at all these rights, there's a lot of them. And, you think about your basic planning process, you don't get to avail of all of these at the first stage in the county council process. So when someone makes an objection to your planning permission, you don't get to have an oral hearing where you get them up in a witness stand and you cross-examine them or get a barrister to cross-examine them. That doesn't happen. And that goes back to what we talked about in the previous lecture, where we talked about the spectrum of fair procedure rights that increases as the seriousness of the situation increases. So as you go on up through the process, your fair procedure rights increase. So at county council stage, it's just the planning decision is made in the planning office and you don't get a hearing. At on board Panola stage, you can request an oral hearing, and if they think it will improve the decision-making process, they may choose to grant it, but you don't have an automatic right to an oral hearing where you get to cross-examine and all that. And then in court, when you judicially review the on board Panola decision, you do get your right to a hearing because it's your last stage, it's your last gasp, if you like. So you get your full gamut of procedural rights then. Ultra vires means outside the power. So every public body is set up by legislation. They're always set up by legislation. If they're not set up by legislation, then they shouldn't be operating. And the legislation that establishes them and gives them their decision-making powers will set out the boundaries of that power. And anything they do that exceeds the boundaries of that power or moves beyond it will be invalid. So as I said earlier, it's like the lines on the pitch. If you move outside the lines on the pitch, if you're playing outside the permitted area, then that play is invalid. So any actions you take outside the margins of the pitch, that's not a valid part of the football game. And it's the same in public bodies. They're confined, the lines of the pitch are the legislation establishing them. So in the case of a planning decision, the lines on the pitch are the planning acts. Anything the county council do that's outside the remit given to them by the planning acts will be invalid. And a decision made that goes outside their powers will be struck down. So Cook and Walsh, the minister, had the power to make ministerial orders to flesh out the details of the medical card scheme as to who was entitled to a medical card. But the minister went beyond that power when he added extra details to, so extra requirements that were not permitted by the Act, he added in. And this went beyond the powers given to him by the legislation, so it went beyond the limits of the legislation and it was struck down. So number 5 is legitimate expectation. So this is the idea that a public body's promises are binding, particularly when people rely on them. So if a public body makes you a promise, you're entitled to expect they will fulfill that promise, particularly if it's one that you will act in reliance upon. So if they say to you, you will be granted planning permission if you do certain works to your land first, and you go away and you expend the money and do the works in reliance on the promise, then they can't go back on it. But the key thing here is the reliance, the acts of reliance. So it must be a promise intended to produce acts of reliance, and that did produce acts of reliance. That's what triggers the operation of the doctrine. So an example of that is Webb in Ireland. So in this case, Mr. Webb and his son were metal detectorists. They went out with metal detecting equipment that was illegal at the time and onto land that they didn't own where they were trespassing, and they found items of great historical value, of treasure trove, known as the Derry Flan hoard. So there were collections of items of gold and silver and jewels that dated back to the time of the monks from the 11th century, and they were of great historical significance and huge financial value. They were going to sell them on the black market, but they realised they were far too big to sell safely, so they contacted the National Museum to negotiate handover of the items, and they asked for a finder's fee. And they were given a promise that they would be given a finder's fee commensurate with the value of the items, which they took to mean a percentage, like a kind of 10% or thereabouts of the items, which would be the usual. And the finder's fee that was eventually offered to them was far less than this, and they took the case to court to dispute that and to argue that they were entitled to a finder's fee relevant to the value of the items, which were in the millions. And the National Museum had to give them a finder's fee. Even though the National Museum argued they were not the owners of the goods, they had found them illegally, none of that mattered. The National Museum given them a promise: if you hand over the items, we will give you a percentage of the goods. And in reliance on that promise, they handed them over. And that's the detrimental reliance that triggered legitimate expectation. So if a planning authority makes you a promise, you're entitled to have them act in accordance with that promise. Another example, Fauke and the Minister for Justice. So refugees from the Lebanon arrived in Ireland, applied for refugee status, and were rejected immediately without their application actually being considered at all. And they successfully judicially reviewed this decision, arguing that under the relevant UN treaties, so the Geneva Convention and other refugee treaties that apply to them, they were entitled to have their application at least considered within the rules of the scheme. And the initial refusal was overturned, and they were allowed to have their decision process fully. So, number 6 then, irrelevant considerations and improper purpose. So a decision may be open to challenge on grounds that the decision maker has failed to take into account relevant considerations, or to have based their decision on irrelevant matters which it was not proper for them to take into account. Irrelevant considerations would be the personal circumstances of the applicant. Relevant considerations include the development plan, proper planning, sustainable development in the area. If a decision is made for improper purpose, this will amount to taken into account an irrelevant consideration. So if the planning decision maker refuses the decision because they don't like the person who's making the application, that's an improper consideration. If the person is refused planning permission because the planning authority says they have previous convictions for road traffic offences, that's an irrelevant consideration also. It doesn't make them look good, but it's not relevant to proper planning and sustainable development of the area. On the other hand, convictions for breach of the Planning Act is relevant, and your planning history, if you failed to comply with planning conditions in the past, that can be brought up against you. So that's that. So that's judicial review and the principles applicable to it. And we'll look at a question now that commonly comes up on this topic. So you will have seen this question on the past paper questions that are under the planning topic. And this is a question about refusal of planning permission by On Board Penola. The reason, so the applicant is Betamax, you're advising them, and the reason they refused planning permission is because of concerns that the development would pose a risk to the health of residents in the local area. No evidence was offered at any stage of the process of risk to human health. The assessment of the process indicated no such risk. There is no basis for this conclusion. Advise Betamax as to the process involved in challenging a decision of On Board Penola by way of judicial review and the applicable legal principles. So they're the principles that we've just looked at in the two related videos, Judicial Review Part 1 and Part 2. And so, first of all, is the idea of procedural versus substantive review. So, did this decision, the courts will first try and review the decision on procedural grounds, and then only in cases where the decision is clearly without any basis in substance will they review it on substantive grounds. So, the solution to that is set out in the guideline solution, but it's important to remember that you must bring your own research to the topic as well as covering the basic points that we've covered in lectures. You have to bring your own independent research at level 9. But we'll talk about that in class. Thanks.